Welcome to the Senate Labor Committee. The Senate Labor Committee is now called to order. I'll note for the record that we do have a quorum present, and we are starting at just a little after 12:35 here in the afternoon. And on our agenda today is Senate File 4483, which is a bill brought to us by Senator Oumou Verbeten, Senator Oumou Verbeten, who is also on our committee. Senator, I believe that you also have an author's amendment, an A1 amendment that you'd like to go ahead and adopt to get the bill in the form which we can hear testimony and talk about it with. Is that correct?
Yes, Madam Chair. I'd like to move the author's amendment.
Okay, members, Senator Oumou Verbeten moves the adoption of the A1 author's amendment. All in favor say aye.
Aye.
Aye. Any opposed say nay. All right, the A1 amendment is adopted. Senator, to your bill.
Thank you, Madam Chair. Before I get started, I just want to acknowledge our brothers and sisters and siblings in labor who are here with us today, who've been fighting very hard to address employer misclassification fraud, and this is a really important step. I'm so proud to be carrying this legislation, but really it is the folks behind me who have been fighting for this work. So I'm looking forward to talking about it with you all today. Employer misclassification fraud occurs when employers mislabel employees as independent contractors to avoid their responsibility to provide their workers with guaranteed protections like overtime pay, minimum wage, unemployment insurance, paid family medical leave, earned sick and safe time, and more. And employer misclassification fraud affects everyone: workers, business owners, and the community at large. It steals wages, benefits, and dignity from workers. It hurts law-abiding business owners who struggle to compete with those who break the rules. It steals resources from our social safety nets, like unemployment insurance and paid family medical leave. It forces taxpayers to pick up the tab for unpaid health care bills that should have been covered by employers. And the payroll tax evasion shifts the tax burden onto everyone else. Employers who commit misclassification fraud use the money that they steal from workers to offer artificially low prices and undercut their competition. It's a race to the bottom, and it has gotten out of hand. This is why the Attorney General, Keith Ellison, created a task force to study misclassification and to make policy recommendations to the legislature. I was proud to be our Senate appointee on that task force, but it brought together key stakeholders and experts across different industries. Members of the task force included Representative Emma Greenman, who served as one of our co-chairs, Rod Adams, the executive director of the New Justice Project, Commissioner Nicole Blissenbach, Octavio Chung-Bustamante, marketing representative from LIUNA, Melissa Heising, legislative director for Minnesota AFL-CIO, Bert Johnson, general counsel for the North Central States Regional Council of Carpenters, Brianna Kemp, policy lead for Tool, Amir Malik, a compliance manager for Bloomington City Attorney's Office, Commissioner Paul Marquardt, Deputy Commissioner Evan Rowe, Aaron Sojourner, a senior researcher with W.E. Upjohn Institute for Employment Research, Brittany Vanderbilt, owner of Vanderbilt Consulting, Kim Vu-Dung, associate professor from Mitchell Hamlin School of Law, Jonathan Weinhagen, the president and CEO of the Minneapolis Regional Chamber of Commerce. I've also included in your packets just information about that task force, the members, so you can look at that yourself. But this bill is a set of recommendations that was adopted by our task force. It's the result of months of meetings and testimony from workers and businesses and policy experts. This legislation strengthens deterrence and enforcement of our current laws against misclassification fraud, and does that in several ways. It gives Minnesota's enforcement agencies the tools to detect, investigate, and enforce the law to protect workers, law-abiding businesses, and Minnesota's social safety net. It's really a whole of government approach to misclassification fraud. And what it does is it establishes an intergovernmental misclassification, enforcement, and education partnership to increase coordination and collaboration among the 5 different government entities responsible for investigating misclassification fraud, which is Labor, Deed, Revenue, Commerce, and the Attorney General's Office. It will also increase penalties for employers who commit misclassification fraud and give the Department of Labor the legal tools to disincentivize system non-compliance. It will strengthen enforcement authority and remedies in the construction and independent contractor statute and the contractor registration system. It will also allow our agencies to educate business owners who are trying to do the right thing and follow the rules, and it will help workers by giving them a one-stop shop to get information and submit complaints. One of the things that we learned in our time on the task force is that it's sort of this hodgepodge of different agencies controlling different aspects of misclassification. Some are looking at it from the unemployment insurance route. Some of them are looking at it for tax evasion. And they need to collaborate better. There's laws on the books that they need to enforce, and this legislation is going to help them do a better job of collaborating and working together to enforce those laws that are on the books. And then the last thing is just that it gives workers the right to go to court when they have been misclassified. So again, I just want to say that it impacts all of us. Workers deserve their hard-won workplace rights and protections. Law-abiding business owners shouldn't be forced to compete with these employers who break the rules and drive down prices and force out their competition. Minnesotans deserve better because employer misclassification fraud is costing us millions, and we really do need to get serious about tackling this issue. So we should give our agencies the tools that they need to detect, investigate, and enforce the law. That's what this bill does, and I would like to invite up Commissioner Blissenbach to just give us a more detailed explanation of the bill.
Thank you, Senator. Welcome, Commissioner Blissenbach. If you'd please introduce yourself formally for the record. We look forward to your run through of the bill. Thank you.
Great, thank you, Chair and members of the committee. My name is Nicole Blissenbach. I am the Commissioner of the Minnesota Department of Labor and Industry. Thank you for the opportunity to testify in support of Senate File 4483, the bill addressing employer misclassification fraud. Misclassification fraud has a significant impact on employees, law-abiding employers, taxpayers, and our social safety nets. Currently, the law addresses misclassification in a piecemeal approach and does not set government up to successfully address this problem or prevent the problem from growing. This legislation specifically addresses deficiencies in laws meant to address general misclassification and misclassification in the construction industry. Many of the changes outlined in the legislation are direct responses to challenges that DLI has experienced in enforcing the current law. The legislation will provide more clarity, which will promote compliance and allow investigations to be more streamlined and impactful. It will streamline and expand enforcement authority, and the legislation strengthens the consequences for employers who violate the law. This legislation will help DLI and the state combat misclassification across all industries. With that, I'll go into a section-by-section walkthrough of the bill. Sections 1 through 5 strengthen investigatory authority of the Commissioner of Labor and Industry. It adds construction misclassification to the department's compliance order authority. It clarifies and enhances penalty authority. Section 6 adds misclassification to the grounds for a private right of action, which before this existed for construction industry employees, but not employees in other industries. Section 7 expands and more thoroughly details both prohibited activities and remedies and penalties in the general misclassification statute. It adds additional damages and penalty provisions to those existing elsewhere in state law. allows for individual and successor liability, expands reporting of violations to relevant local agencies. Section 8 is the provision that tackles construction or misclassification in the construction industry. It clarifies and broadens application of the independent contractor test to business entities as well as individuals. It modifies the existing test for construction to make the factors clearer and easier to understand and apply. It retains the presumption that an individual performing or providing construction services is an employee unless they are operating as a business entity that meets all factors of the independent contractor test. It refines and clarifies the independent contractor test for persons providing or performing building construction or improvement services, really focusing on two core questions. Is the asserted independent contractor a separate and legitimate business entity, and is the contractual relationship a legitimate business-to-business transaction? It addresses who the employer is in instances where misclassified workforce is retained through a multi-tiered and layered chain of purported independent contractors. It expands and more thoroughly details both prohibited activities and remedies and penalties. It requires that a person treating an individual as an independent contractor retain records that determination is based on and provide those records to the department upon demand. It allows for individual and successor liability. Sections 9 through 10 establish an intergovernmental misclassification enforcement and education partnership and outlines the composition, roles, and duties of the partnership entities. The purpose of the partnership is to increase coordination and collaboration among the 5 different government entities: Revenue, Commerce, Labor and Industry, Deed, and the Attorney General's Office, all of which are responsible for investigating and enforcing violations related to misclassification. The partnership is charged with setting goals to maximize efforts to detect, investigate, and deter misclassification. Sections 11 and 12 provide authority for the Commissioner of Revenue to share data with Commerce and the Attorney General for purposes of misclassification enforcement. Section 13 provides more enforcement tools for violations of these statutes and updates definitions to better align with other changes in the proposal. Sections 14 through 24 enhance and clarify investigative and penalty authority, including penalties for failure to remedy notices of violations, assessment of damages, penalties for obstruction of investigations, and expands grounds for summary suspensions of permits, certificates, licenses, and registrations. It allows orders to be issued against individuals. It changes stop orders, which allow the commissioner to order cessation of unlawful practices, to stop work orders, which allow the commissioner to order the cessation of all business activities for engaging in certain violations or failure to comply with orders of the commissioner. It makes stop work order effective against successor persons and grants a right of up to 10 days of average daily pay for workers who have been impacted by stop work orders. Section 25 clarifies applicability of the registration requirement. This is the contractor registration provision. It clarifies applicability of the registration requirement by better defining covered work and geographic scope, and clarifies and modifies information and documentation needed for registration. It clarifies prohibited activities and explicitly prohibits requiring misclassified employees to register as contractors. It replaces investigative and enforcement authority in the section with authority set out in other statutes, and it expands permissible use and sharing of application data. So that gets us through each of the sections. I will be remaining in the committee if there are questions for me or any questions for the department. Thank you.
Thank you very much, Commissioner Blissenbach. Should we proceed with our list of testifiers then, Senator?
Yes, thank you, Madam Chair.
Okay, and I believe next we have Melissa Heising. If you'd please introduce yourself for the record and proceed with your testimony.
Thank you. Good afternoon, Madam Chair and committee members. My name is Melissa Heising, and I'm Legislative Director for the Minnesota AFL-CIO. I'm filling in today for our Secretary-Treasurer Brad Leto, who could not be here today. I'm also a member of the AG's Task Force on Worker Misclassification. The Minnesota AFL-CIO is the state federation of more than 1,000 local unions who represent over 300,000 working people in every corner of our state in nearly every kind of job. Our labor movement envisions a state where all working people, both union and non-union, have safe workplaces, a job that can sustain a family, time to spend with our families, and a dignified retirement. Today, I'm here to speak in favor of Senate File 4483. Working people have an expectation that state and federal laws designed to protect them will apply no matter where they work. They expect that long-standing labor rights and protections like minimum wage, workers' compensation, overtime pay, access to unemployment benefits, the right to collectively bargain, and more will apply to them. Sadly, far too many employers across industries, such as construction, transportation, retail, warehouse work, entertainment, sports, nonprofits, and building services, and more, break the rules to cut their costs by classifying workers as independent contractors while demanding the same expectations as if they were employees. This improper misclassification deprives workers of both the long-standing protections I mentioned earlier and the hard-fought protections we passed in 2023, such as paid family and medical leave and earned sick and safe time. Senators, working Minnesotans have had it with low-road employers who deprive them of their rights just to save a buck. It's time for Minnesota to strengthen and streamline enforcement of our worker misclassification laws to discourage this unfair and illegal practice. Senate File 4483 will begin to accomplish this goal. Thank you.
Thank you for your testimony. Next, we have Mark Bradley, and after that, John Thorson. Welcome to the Senate Labor Committee. If you'd introduce yourself and proceed with your testimony.
Thank you, Madam Chair, members of the committee. Good afternoon. My name is Mark Bradley, and I serve on the Twin Cities Local Board of SAG-AFTRA, the Screen Actors Guild, American Federation of Television and Radio Artists. I'm here today in my capacity as Chair of the Local Government Affairs and Public Policy Committee. In my remarks today, I will frequently refer to talent, which is the common generic industry term for actors, announcers, singers, extras, and other performers. The industry means the recorded media industry, in which performances by talent are recorded by audio or video technology. It does not include live performances. Imagine you're a non-union talent and you're engaged to perform in an independent film. You're hired as an independent contractor. You arrive at a studio or other location when you are called. You perform a script that you have been given, and you are directed in your performance. You are paid sometime later, usually by the non-union agent who got the job for you. The agent may charge you well above the 10% that is mandated in a SAG-AFTRA agent's franchise, and they may also charge a client placement fee. It should be obvious from the example given that you should have been classified as an employee. There is precedent going back at least to 1957 that states that talent are employees. Every common law test says that talent should be employees, including the 20 questions from 1987, the 3 questions from H.R. 1525 of 1999, and other tests. It is also clear that the wishes of the parties involved are irrelevant for proper classification. In the DeQuisto case of 2000, a voice talent argued that he wanted to be an independent contractor so he could deduct his business expenses from the first dollar on Schedule C. But the court said that it was the nature of the relationship that made him an employee. A 2007 study by the Office of the Legislative Auditor has even said that in Minnesota, misclassification is worse in our industry than in construction. It's clear that employers in the Minnesota recorded media industry are taking advantage of the current leniency around misclassification. SAG-AFTRA would like to see that talent in the recorded media industry are clearly and definitively classified as employees, with one important carve-out. Our singer-songwriters should enjoy union wages and protections, but there needs to be a clear stipulation that they retain intellectual property rights to their work. Thank you for your time and attention.
Thank you for your testimony. Next, we have John Thorson, and after that, Laura Ziggler. Welcome, Mr. Thorson.
Thank you, Madam Chair. Members of the committee, my name is John Thorson. I am here on behalf of LiUNA, Minnesota, North Dakota, a union of more than 14,000 men and women who build and maintain our critical infrastructure throughout the state. Before you today to support Senate File 4483 because the intentional misclassification of workers is a widespread and pervasive practice in the construction industry. A 2021 report from Midwest EPI found that over 30,100 Minnesota construction workers were either misclassified or paid off the books, accounting for 23% of workers in the industry that year. Another report published last year by the North Star Policy Action documents the use of contractors tied to either proven or alleged exploitation of workers on affordable housing projects that have received over $84 million in taxpayer subsidies. By far, the most common form of exploitation uncovered was worker misclassification. Misclassification is prevalent in every subsector of the construction industry. We find that it exists in both privately and publicly funded projects. We've encountered multiple cases of misclassified workers installing broadband infrastructure throughout the state. And we find contractors both large and small, including stone veneer installers by a multi-billion-dollar stone manufacturing and installation corporation. Misclassifying workers is so prevalent and widespread in the construction industry because the financial incentives are so great and enforcement is diffuse and lax. Contractors who misclassify workers are not contributing to payroll taxes, unemployment insurance, or workers' comp. It's a business model that allows them to underbid contractors who are law-abiding, have high road labor practices, and who play by the rules. Far too many owners will look the other way when presented with an unreasonably low bid for the price of a project. And we find when serial abusers who do get caught, they simply pay their fines and then go on to work on the next project. Madam Chair, Senate File 4483 will give the state more tools to prevent the illegal exploitation of workers in Minnesota's construction industry, and I encourage you to support the bill. Thank you.
Thank you for your testimony. Now we have Laura Ziggler. Welcome to the Senate Labor Committee. Next up, also, we have John Hosladen.
Thank you, Madam Chair, members of the committee. My name is Laura Ziggler with Associated General Contractors of Minnesota. We represent over 350 commercial contractors. These are generals, subcontractors, specialty contractors, and suppliers. We are the state's oldest and largest commercial construction association, having been in existence for 105 years. For the purposes of this discussion here today and of significance to the bill, our members are commercial contractors. They do not perform single-family residential construction. Additionally, over 80% of our contractors are signatory to a union and are signed to a collective bargaining agreement. AGC contractors maintain the principal relationships with organized labor in the commercial construction sector, and our association negotiates collective bargaining agreements with over 15 different trades in both the commercial building and highway market sectors. Our members are committed to the AGC creed of skill, responsibility, and integrity. It is our belief, and it is my belief, that the intent of many people addressing this issue is to hold bad actors accountable. We also believe that should be done while protecting all of the employers and independent contractors that play by the rules and follow the laws. While we are still digesting the bill's full effects, our concern with Senate File 4483 is that the legislation needs to consider a more focused approach on the bad actors and where we can improve upon coordination and enforcement as a state. Employers must be able to adequately manage their operations in the same way that individual workers should be able to choose how they participate in the workforce. We believe that important components of this discussion will also occur next week with the Office of Legislative Auditor's report on worker misclassification that will be released. And we also strongly encourage that construction employers' concerns are heard and reflected in any future versions of this legislation. Initial concerns are that this legislation is far encompassing and instead should take a precision approach. As drafted, it is broadly punitive and provides penalties without regard to knowledge or intent. The bill does hold potentially unsuspecting persons liable for punitive damages, such as other owners or partners, employees involved in the management, and includes foremen and forewomen on the job. Our other primary concern relates to the construction industry independent contractor test changes in the bill. As previously mentioned by the Commissioner, there are several additions to this test. So there are 14 requirements up from the current 9-factor test. So for example, the new multi-part independent contractor test for construction requires a written contract before service for a stipulated sum. This alone makes change orders very complicated, and those are necessary to complete projects and make the contractor whole. It also prohibits cost-plus contracts. Those are extremely common in the industry. For project delivery, they help ensure quality, and they also promote strong long-term relationships. This contracting method mitigates risks on work that is very difficult to bid, which can in turn reduce barriers for contractors, particularly those emerging in the industry. Before concluding my comments, Madam Chair, I would add that conceptually we are okay with the proposed intergovernmental misclassification enforcement and education partnership also included in the bill. But the changes to the multi-party factor test are significant to us, and we are concerned about that broad punitive nature liability also included. Madam Chair, members of the committee, thank you for the opportunity to provide comment and observations here today.
Thank you for your testimony. Mr. Hausladen, did I pronounce your name correctly?
Hausladen, thank you.
Hausladen, welcome to the Senate Labor Committee. If you'd introduce yourself for the record and proceed with your testimony.
Good afternoon, Madam Chair, members of the committee. I am John Hausladen, President of the Minnesota Trucking Association, and I am here today to testify in opposition to Senate File 4483. Trucking is the backbone of Minnesota's economy, and the truck driver is the lifeblood of the trucking industry. We strongly believe that men and women should have the choice to work as either an employee driver or as an independent contractor. And we also strongly believe statutes and regulations that clearly define who is an independent contractor are essential to preventing misclassification. That is why the trucking industry worked in cooperation with organized labor, state agencies, and legislators in 2009 to create a trucking-specific definition of an independent contractor. That 7-factor test can be found in Minnesota Statutes 268.035, Subdivision 25B, and 176.043. And I call them out because they specifically deal with unemployment insurance and workers' compensation insurance. These trucking-specific definitions have served Minnesota well, as complaints of misclassification within the trucking industry over those 15 years have been minimal. And at the same time, they have allowed men and women to realize the American dream of owning their own small businesses on big wheels. Now, I want to stress that trucking independent contractors differ from others in the gig economy. They invest $150,000 or more in trucks. They pay all fuel and operating costs. They assume all the risk when operating on the road, pay for insurance, and of course they manage employees. And get this, they operate under additional federal leasing laws that protect against unfair contracts and define liability. And I have to tell you, the opportunity is great, as trucking companies typically pay independent contractors 2 to 3 times what they pay employee drivers. And Minnesota's trucking-specific definitions also ensure proper payment of all income taxes and fees. There is a nationwide shortage of 80,000 truck drivers. Men and women who want to be a truck driver can choose today to go from one mode to the other. No coercion, total choice. They can be an independent contractor or an employee. We believe that Senate File 4483 creates an expanded regulatory framework that is unnecessary and certainly redundant for the trucking industry. We believe it dramatically increases the overall compliance burden and, has already been said here, the potential for punitive action for unintentional errors. So we urge the legislature to take a go-slow approach and wait for the full report of the Office of the Legislative Auditor before considering any significant changes to Minnesota's misclassification statutes. Thank you.
Thank you for your testimony. Next, we have Peter Coyle, and after that, Adam Hansen. Welcome to the Senate Labor Committee. If you'd introduce yourself and proceed with your testimony.
Thank you, Madam Chair, representatives, members of the Senate Labor Committee. My name is Peter Coyle. I'm a lawyer lobbyist with Larkin Hoffman. I represent Housing First Minnesota for purposes of my testimony today. I also represent scores of contractors that do work throughout the state of Minnesota who are going to be directly affected by this very complicated bill. I attempted to meet with the author ahead of the hearing so I could explain my views to her, but the timing of the bill introduction to today's hearing made it difficult to do, so I apologize for that. So she's going to hear my comments essentially today for the first time. And I'll, of course, be happy to follow up with her if the opportunity presents itself. In a committee next door, they're actually hearing a very positive housing bill that's intended to drive the production of housing throughout the state of Minnesota, both by increasing availability and lowering cost. That's a good thing. It's a bipartisan effort. Housing First Minnesota strongly supports that effort. It's unfortunate then to have this committee hearing a bill which, in my opinion, and certainly respectfully with regard to the author and the supporters, will take us in the opposite direction by increasing regulatory burdens on small contractors and thus driving up cost. And that's an unfortunate outcome. As one who advises contractors on a day in, day out in my law practice, I can tell you from my own experience that this kind of bill scares them to death, not because they don't want to be law-abiding, they are. What scares them is that they're going to make an honest mistake and that they're going to suffer mightily as a consequence of it. And my prediction is that the biggest violators under this new bill are going to be people that make honest mistakes. The bad actors out there, and they exist, I'm not going to suggest that they don't exist, they should be prosecuted in any way possible and put out of the business. But the fact is, they're not sitting there reading bill introductions and bill summaries to make sure that they're staying abreast of the latest development in the statutes, because they're bad actors, and they're going to violate the law if that's what they think is in their own personal best interest. So again, very respectfully, I would suggest to you that this is a very, very complicated bill. It's going to be very difficult for smaller contractors working in your districts to be able to adhere to the law because, frankly, they may not have ready access to the professionals that are necessary to help them understand and implement the statute once it's implemented, assuming it is. The second comment I would make, which is really more philosophical, Housing First Minnesota, as the state's largest trade group representing home builders in Minnesota, was not invited to participate in the task force, fair enough, nor were they invited to participate in any of the conversation leading up to the development of the bill. And that, to me, is an unfortunate oversight, I'll say that. It's a practice that we've seen previously, which is disappointing given the extent of the business presence that this trade group has in Minnesota. We want to see the law enforced, we want to see the law complied with, but we also want to do our best to try to minimize negative consequences for smaller operators that lack the resources to be sure that they're compliant. I just have a couple of very technical points, and Madam Chair, and I'll wrap up my testimony. First of all, I echo the comments made by the previous testifiers that the bill now assigns new legal responsibility on foremen and supervisors who most frequently lack any knowledge about the hiring practices of their employer, let alone in some cases the employees that they may be asked to supervise on a day in or day out basis. The second thing I would say is the bill really will be punitive as to those independent contractors that choose to work with multiple contractors throughout the state, because that's the best way for them to keep their company busy and their employees busy. But by definition, this bill is trying to take the state in the opposite direction. And then the final comment I would make, which others have said, the imposition of limits on cost-plus contracts by banning them. If you recall, not too many years ago, we went through a very, very inflationary time in the construction industry during the COVID shutdown period. I could tell you from my own involvement with contractors, there isn't one of them that would sign a contract for a project if they had to bear the risk of the inflationary costs on their supplies, because in some cases, there were supply material increases that were occurring weekly, if not monthly, if not semi-annually. They're too small to absorb that risk, and yet this bill would prevent them from being able to protect themselves from that kind of an inflationary cycle. It wasn't their fault, wasn't anybody's fault here, and yet they would bear the negative consequences of that in the future. Madam Chair, with that, I'll stand down. I appreciate the chance to testify here today in front of the committee. I respect the work that the Senate author has put into this bill, and certainly the supporters, but I would urge the committee to take a hard look at advancing this bill out of committee, at least until we see what the auditor's report indicates to the legislature in the coming weeks. Thank you very much.
Thank you for your testimony.
Thank you.
Next, we have Adam Hansen. And following Mr. Hansen, we have Richard Kajiski.
Thank you, Madam Chair and members. My name is Adam Hansen. I'm with Associated Builders and Contractors, the Minnesota North Dakota chapter. ABC is a trade association made up of 340 commercial and industrial construction companies and their 20,000 employees. The men and women that they employ are part of the 75% of Minnesota's construction industry that choose to be merit shop craft professionals. ABC promotes fair and open competition and free enterprise in the industry in which anyone can succeed based on merit. We oppose violence, coercion, intimidation, and the denial of those rights of both employees and management. We have strong concerns with Senate File 4483, which among other things makes drastic changes to the time-tested independent contractor laws that took 2 years to develop with both labor and industry over 2 years. We followed the work of the task force on misclassification throughout the interim and paid particular attention to the recommendations that were put out in February. Much of the attention was given to strengthening enforcement actions by the various state agencies and finding ways to improve interagency collaboration. Given this focus, it would have been appropriate to look at better ways to enforce existing laws rather than creating a new complicated 14-factor test. As written, this bill would result in more confusion by doing away with the existing 9-factor test and replacing it with that 14-factor test. Failure to satisfy just one of those factors can result in fines and liabilities and maybe even loss of your business. Here's an example. If you're a painting contractor and you have a large commercial construction project that you're hired for, the contractor, you're properly registered with DLI, you have your own employees, you have your own equipment, you have your own paint that you provide and you purchase and all the supplies needed for that job. But if one of your employees is sick that day and uses their sick and safe time to not be at work, that painting contractor might call upon a local independent contractor to come in and fill that labor gap. That independent contractor is properly registered with the state and satisfies 13 of those 14 factor tests under this bill, but it fails one of them, and that's to provide their own materials. In this scenario, that independent contractor would be treated as that painting company's employee just because they were provided paint to finish that job. Or how about a little bit closer to home, something that maybe you can understand. You want to replace a ceiling fan in your house, you want to maybe repaint your kitchen or a bedroom or a bathroom, or replace tile in your kitchen. You go to Home Depot or your local home improvement store, you buy the fan, you buy the paint, you buy the tile, and you call a local handyman or a local remodeler, an independent contractor who's properly registered with the state. Under that same factor test, because you provided them with those materials to finish the job, they're now classified as your employees, and you need to pay them overtime, workers' comp, and other penalties related to that. And under the bill, there's at least a $5,000 to $10,000 fine to the homeowner there. I hope this isn't the intention of the bill or those supporting the bill. Line 10.6, which is, if you're following along, is subpart 4 of part 4 of the 14-factor test, requires someone to have 24 months of independent construction experience before they can apply to be an independent contractor. But they can't get that work unless they are an independent contractor. So it's great for a segment of the industry that wants to keep people out of the industry, but it's not good for somebody who wants to break into the industry. Finally, I'd want to point out that the effective date of this bill is August 1st, just a few months from now. If passed, this leaves an incredibly short period of time for contractors, their subcontractors, as well as independent contractors to figure out what is in this bill. And I sure hope we can count on the Department of Labor and Industry to get guidance out to contractors and trade associations like ABC and others so we can educate our members so we can be compliant. In closing, this bill is designed, I think, to make it nearly impossible for honest contractors to satisfy these requirements. This week is also National Women in Construction Week. For a woman who is looking to get into the construction industry on her own, start an independent construction business, and own her own labor, as opposed to being an employee for somebody or a member of a labor union, this bill tells that woman no, she can't do that. We respectfully request a no vote and reconsideration on this bill. Thank you for the opportunity to testify.
Thank you for your testimony. Next, we have Richard Kaji. Welcome to the Senate Labor Committee. If you'd please introduce yourself and proceed with your testimony. And next up, I'll note we have Michaela Tur.
Good afternoon, Madam Chair and Senators. I'm Richard Kaji, the Director of Government Affairs for the North Central States Regional Council of Carpenters. I represent over 12,000 carpenters, industrial workers, millwrights, pile drivers, and interior systems carpenters throughout Minnesota. Senate File 4483 offers employees who might previously have been misclassified an opportunity to receive the essential benefits and protections all workers should be afforded, including overtime, minimum wages, better safety standards, and additional benefits. I began my employment with the carpenters over 4.5 years ago. For years, I arrived before 7:30 a.m. to an office building just down the street from this building. It opens to the public at 8 o'clock a.m., Monday through Friday. Sadly, nearly every day of my career, prior to my arrival, workers who've been exploited through wage theft, tax fraud, and often worker misclassification fraud are waiting outside of our building to speak with business representatives. It's become a revolving door. I have documented, listened to, and videotaped more of these stories than I should have to. Each one is sadder than the next. Children are left without life's essentials. Hardships are manufactured at the hands of greedy employers, and a wake of victims are left in the path that include each of us in this room. For far too long, employers have found ways to require someone to work as an independent contractor. This bill levels the playing field for honest contractors who are not cheating the system and properly treating their workers as employees. With this legislation, dishonest employers will no longer get away with undercutting honest contractors who are not cheating workers out of benefits that they are entitled to. Madam Chair and Senators, I urge you to support this bill. Unfortunately, current laws don't provide much of a deterrent against misclassification fraud. However, this bill addresses enforcement, protects our small businesses, and will deter dishonest business owners from trying to cheat the system. Minnesota needs this legislation. The burden of misclassifying workers falls on the backs of hardworking taxpayers. All too often, these workers don't pay any payroll taxes and don't have any workers' compensation insurance. They don't receive benefits. And if they're paid at all, it's so little, it makes it virtually impossible to pay for these things and buy groceries for their families. Senators, I ask you, please, let's put an end to this. Let's do what's right to protect workers, and let's do what's right for Minnesota. Thank you.
Thank you for your testimony. Next, we have Michaela Tur, and after that, Charlie Cushing. Welcome to the Senate Labor Committee. If you'd please introduce yourself and then proceed with your testimony.
Yeah, absolutely. Good afternoon, Madam Chair and committee members. My name is Michaela Tur, and I'm an organizer with the Minnesota AFL-CIO. However, before I joined the Minnesota AFL-CIO team, I was an organizer for a 501c3 organizing project that spanned across multiple states, and I was a 1099 contractor for nearly 3 years. I'm here today to speak in favor of Senate File 4483. When I first took this organizing position, I was still in college and I was really excited to have a decent paying job. However, what I did not know was that this job was as a contractor. I signed the contract not knowing that this was any different than any other W-2 employee positions I had held before. It wasn't until after my first month that I was told to submit an invoice for my hours, and I saw that there were no taxes taken from my paycheck. This was when I realized I had been hired as a contractor. As a 21-year-old, I didn't even know someone could hire me as a contractor like that, especially because this job operated like any other job I had had previously. When I started working full-time, I asked questions as to why I didn't have access to benefits and employee status. As I talked more with my coworkers, we realized that we were misclassified employees. Our boss had told us multiple times that he highly preferred that we didn't take on other contracts as it might interfere with the full-time work we were expected to do with him. We were not given the ability to set any terms of our contracts that we signed every 3 to 6 months. We were not allowed to bill for any overtime hours on our invoices. We were trained and directed to do the work as our boss wanted it done. Our boss decided what holidays and time off we received, sometimes paid time off and sometimes not, depending on his mood. And we were issued work equipment in some situations, but not all. Many of these factors do not pass the IRS test for being 1099 contractors. Many of my coworkers and I were upset about this, and we came together in solidarity to start asking for a pathway to become employees. Because we were contractors, we were not able to officially unionize, but we did form a solidarity union, and we did go on strike twice when our contracts were expired and coworkers were not being paid. However, because we all worked in different states and worked mostly remote as a team without a central location for our employer group, we weren't sure what government body to report our issue to. And because I was the only one of my coworkers working in Minnesota at the time, I didn't know if there was any action I could take in this state. This is why I'm really excited to see legislation like Senate File 4483, so future workers will have recourse when they're misclassified. While some opponents of this bill will make arguments that many employers are just making good faith mistakes when misclassifying employees, I need them to know that their good faith mistakes cost me and other workers thousands of dollars, not just in lost benefits and protections, but also fines. I was unaware that as a contractor, I was required to pay quarterly taxes and not yearly taxes like W-2 employees. I learned this through a fine that I had to pay to the IRS when I went to file my contractor taxes for the first time. I wasn't allowed any forgiveness. Their good faith mistake cost me, a working class individual, hundreds of dollars. I appreciate your time today to share this experience, and I'm excited to see you all tackling this issue in Minnesota. Thank you.
Thank you for your testimony. Next, we have Charlie Cushing, and after that, Jesse Madison. Welcome to the Senate Labor Committee. If you'd introduce yourself and proceed with your testimony.
Madam Chair, Committee, thanks for giving me the opportunity to speak today. My name is Charlie Cushing. I am the business representative of the International Alliance of Theatrical Stage Employees, Local 745. Since 2009, we've represented over 250 talented broadcast technicians throughout Minnesota and Iowa. My introduction to misclassification started in 2016 when a group of broadcast workers employed by the Minnesota Timberwolves, who were responsible for the in-house production on the Jumbotron, approached my local about organizing a union in their workplace. Their primary reason for seeking union representation was in 2016, the last time they had received an increased wage was in 1997, 19 years earlier. After receiving overwhelming support, we filed for a National Labor Relations Board election. This then set off a 15-month series of events attempting to determine whether or not these workers were employees or independent contractors. Ultimately, we prevailed. The NLRB in Washington, D.C. issued a ruling in August of 2017 determining that they were misclassified and were indeed employees. After a 15-plus month wait, we were unsuccessful in an NLRB-conducted election. Even after a federal regulatory agency found the Timberwolves to be in violation of U.S. labor law, it was not until 2022, 6 years later, the team finally complied and started paying these workers as employees. The second example where we've experienced misclassification was immediate. In 2016, the year that U.S. Bank Stadium in Minneapolis opened, the in-house production workers for the Minnesota Vikings were paid as non-union W-2 employees. Less than 10 days after the Minnesota Timberwolves NLRB misclassification ruling, the Minnesota Vikings sent an email to the in-house production crew announcing that they were enthusiastically switching everyone from employee status to independent contractor status paid on a 1099. This was obviously done in an attempt by the team to shield themselves from any risk of future union organizing. The Vikings continue to misclassify their workers at U.S. Bank Stadium and their facility in Eagan to this day. Today, down at XL Energy Center right down the street, is the boys' state hockey tournament. Hubbard Broadcasting has had the contract to produce all of the state tournaments in Minnesota. They have misclassified those people since 2004. They misclassified them last week at the girls' hockey tournament, the boys' hockey tournament this week, and the next two tournaments, the boys' basketball and girls' basketball. Misclassification has far-reaching consequences for workers. When you're misclassified, you pay a higher tax obligation, do not receive workers' compensation protection from your employer. You're not eligible for unemployment insurance or paid sick leave. My request of our state lawmakers is create a law that will allow Minnesotans to anonymously report their employer who's misclassifying them so that they do not have fear of retaliation. Thank you for your time.
Thank you for your testimony. Next, we have Jesse Madison. Welcome to the Senate Labor Committee. If you'd introduce yourself and proceed with your testimony.
Thank you, Madam Chair and members of the committee. My name is Jesse Madison, founder and CEO of Purple Tally Productions, Incorporated, based here in Bloomington, Minnesota. I want to sincerely thank you all for including me on the important work you're doing here today. I'm here to speak out in support of SF number 4483. Since 2014, my company has worked to provide staffing, payroll, and production expertise in the live sports, entertainment, live streaming, and corporate production industry. My involvement in this issue began long before I started a company. I myself was a 1099 freelance broadcast technician working here in town beginning in 1996. Back then, everything was 1099 no matter if you wanted it or not. That's just how it was. Thankfully, our broadcast technicians voted in favor of union representation in 2009, which began the change from 1099 to W-2. When it comes to how this issue currently affects my company, last year alone we faced a staggering loss of $105,000. It's a big deal for a small company. It's not just a number either, but it's a testament to the consequences of inadequate enforcement of labor laws. This loss was compounded by the actions of a former client, Joshua Giles Ministries, and their refusal to settle their invoices, further exacerbated by the engagement of misclassified workers through their fellow company, American Horse Labor of Lakeville, Minnesota. These actions not only undermine the integrity of our industry, but they also embolden others to flout the law with impunity. Additionally, if someone gets hurt on their shows, it's not their problem. As you've heard many others testify here today, it's the workers' problem. Who does that benefit? We pay tens of thousands of dollars every year for workers' compensation because we're a responsible employer. We get punished for it when irresponsible employers are allowed to enrich themselves by ignoring these laws with zero consequences for doing so. We fought over the same issue on shows like the Summer X Games at US Bank Stadium back in 2019, right up to the recent World Cup cross-country skiing in Minneapolis, Minnesota. That was just a couple weeks ago, and it was the same company in both cases, a company called Echo Entertainment out of Los Angeles, California. They bring in 1099 labor, a lot of it out of state, to cover a major portion of these shows. It's not just them either. Dozens of other local and out-of-state production companies continue to use misclassified uninsured workers for broadcasts taking place at the University of Minnesota, XL Energy Center, Target Center, and Target Field all year round. In summary, I'm not here to complain and just hope everybody else fixes it. I have a documented history of working with lawmakers and labor leaders to solve these issues, and I'm looking to continue to put action behind these words. Thank you again for including me in the work to solve this issue.
Thank you for your testimony. I believe that concludes all of the testimony for all of the testifiers we had signed up. So thank you, Commissioner, for rejoining. We'll go ahead and proceed to discussion of the bill as amended. Before we do that, Senator, would you like to have any final comments after? Okay. All right. To discussion of the bill. Members. Yes, Senator Dornick.
Thank you, Madam Chair, and thank you for bringing this bill, Senator. We have the same goals to punish those that are abusing the system and misclassifying workers and taking advantage of them. I appreciate the testifiers that came both pro and con or for and against, and that's our job up here is to, I've said it last year, I haven't said it this year, but labor and industry. My job is to be the and, to be that partnership, to be able to take this in and try to not take a side, but look at the facts and go through and decide what is best for Minnesota, what is best for the workers and for industry. And sometimes that's difficult. And in this one, it's very difficult. We hear very compelling arguments on both sides. And so I take this very seriously. I am a carpenter. I was a union carpenter for 22 years, and I work beside some of you that are out there, and appreciate your work. It's great to see you again, some of you. And so this is a very important issue to me. Unfortunately, I got laid off in 2009, just the economy, and I had a choice. I had a large family, some of you guys know that, but anyways, and I had to take my skills and work as a general contractor, because it was going to be 2 years before I could get back to work. And I talked to my BA, and he says, you have to provide for your family. And so that's what I did. And for the last 14 years, I've been a general contractor in the residential. So I have a unique position of being in both sides. And so going through and being able to see both sides and taking in this information and trying to do the right thing, which sometimes it's hard to know. And we so want to be so very careful that we don't have unintended consequences by some of the things that are in this bill. And part of the problem that disappoints me is that I'm seeing businesses, there's 11 of them here that have a letter to us about some of their concerns, and they feel like they haven't been heard. And that bothers me. Not that, they have real concerns, and I have real concerns because the speed of this bill, I just got it, we just got it Monday, amongst our schedule of all that we have to do. And I'm not an attorney, I'm a carpenter that wants to serve the people in this venue here as a state senator, and it's been a privilege to do that. So I'm trying to assimilate all this stuff, and it's been very difficult. And so the speed of the bill is a real concern to me. So I think there's some things that we need to address. So with that, I'm just a couple of questions, Madam Chair, if it's okay, to the Commissioner and the Senator.
Please proceed.
So a little bit about the task force background of a little bit of that information, just kind of brief, I'm not looking for a lot, but just a little bit towards that. How was the membership chosen?
Senator?
Madam Chair, Senator Dornick, in your packets, I did include that list of the members who are part of the task force. What I can say is that the Attorney General wanted to make sure we had a broad range of diverse voices at the table, so that we had workers, we had business owners, we had sort of experts in this area who study this policy. That's why we had representatives from the Chamber of Commerce who were part of the task force, why we had our commissioners as a part of the task force, some of our labor unions. We also had several meetings where we heard from workers, business owners, again, those policy experts. So our Attorney General wanted to make sure there was a diverse set of voices on that task force. And I believe when it was first created, there were some of those sort of categories that were set out. Folks were able to apply for those positions. And then the resulting list of task force members that you see is who applied to be a part of it.
Senator Dornan.
Thank you for that. So I do have a question that I see that's missing is, you know, with the Workmen's Comp Advisory Board, you have a real balance, 6 business, 6 labor, and then they have 4 of the legislators, 2 Republicans, 2 Democrats. And what I see missing here is bipartisan, well, of the table. Representative Greenman, I think, and then yourself. That was the only 2 legislators I think I saw on the list. Is that correct?
Senator?
Madam Chair, Senator Dornick, those are the 2 legislators who agreed to be a part of the task force.
Senator Dornick.
Thank you, Madam Chair. So I guess I didn't know about it, so I would have done that. I would have been available. But moving on, so a little bit to the Commissioner, a question for Commissioner Blissenbach. Thank you for coming. Thank you for the call yesterday. I appreciate that, to give me a little heads up and trying to navigate through the bill. So with bad actors, if you can just tell me the current practice kind of, because it sounds like there's repeated, kind of the same ones continue to more so. Is that true? And then how do you go about prosecuting them or punishing them for abusing these workers?
Commissioner.
Chair, and members of the committee, so it's a bit of a, to be honest, even internally, a complicated process. Misclassification on its own in the construction industry can be, is a violation, so 181.723. When we receive, but it is, the enforcement happens through Chapter 326B, which is our construction code and licensing chapter. So if we get an allegation of a violation of misclassification in the construction industry, and let's say that comes in and the allegation is these workers were misclassified, and because of that misclassification, they were not paid minimum wage or overtime. Both of things that we can enforce: misclassification, construction industry, and wage and hour laws. So that complaint comes in. Those processes for enforcement are 2 separate things. We have to do, for misclassification, we have to do a licensing order or an administrative order through Chapter 326B. We cannot recover wages through that process. If we want to recover wages, we have to issue a compliance order under our authority in Chapter 177. Those timelines don't follow. The investigation process doesn't follow. It's extremely complex. And then we are splitting resources to do 2 separate investigations, 2 separate enforcement process, and to get to the end result of you misclassified and you violated wage and hour laws. That can be extremely resource intensive and does not let us utilize our resources in a manner that is at all helpful. So what we have done to work with the laws as they are is take that case and say, okay, we know that there's probably misclassification here because we have a bunch of workers who are paid cash under the table, no records kept of how long they were working, where they were working, other than maybe random text messages. And we take that case and we just, because we want to recover for the workers, right? The injury that has happened to them, we send it to our wage and hour division, and that is where the investigation happens, which then means there is no violation of the misclassification law that is found and that we enforce, because the process is too complex. It's part of the reason why we are asking in this bill to add misclassification in the construction industry to our compliance order authority. So like when you go to court and you can list, here are all the violations of laws that exist, we can do that in our compliance order authority rather than having to take two separate administrative actions. So that's kind of how the process works currently. I know that that's probably more in the weeds than what you were looking for, but it is just one example of how the law does not set the state up for success in addressing misclassification.
Thank you, Commissioner. And Senator Oumou Verbeten, did you have some comments to add?
Madam Chair, no, I just wanted to let the committee know that I invited Karen Rotz from the Attorney General's office just to speak to any specific questions to the task force as well.
Okay, thank you for joining us. Is there any additional information you'd like to add to the record in regard to the questions that have already been asked?
Sure. At this time, I would like to add, thank you for your question, Senator Dornick. We did the task force by an open appointment process. We announced the openings, we posted them publicly on the Secretary of State's office, and then we received applications from the public.
Thank you for that. And can you introduce yourself formally for the record?
Yeah. Hi, I'm Karen Moratz. I'm the Senior Advisor for Policy and Special Projects in the Attorney General's office.
Thank you very much. Thanks for joining the committee. Yes, Senator.
Madam Chair, thank you. And I just also want to point out that all those meetings were public. All the agendas were posted. I know our staff were following. I imagine other staff in the Senate building were following this. We saw a lot of lobbyists at the meetings. We've been working on this issue very publicly for a while.
We also held 2 full 3-hour meetings that were devoted to nothing but public comment and testimony. We heard from a lot of not just workers, but DoorDash, TaskRabbit, Uber, a lot of the business community as well.
Thank you for that information. Senator Dornick, follow up.
Thank you, Madam Chair. Thank you, Commissioner. I guess I'll let others talk, ask questions. I do want to ask the path of the bill. Do we have a path where it's going next and what committees it will be going to?
We have it listed as needing to go next to state and local government. And yes, Senator Oumou Verbeten might have some more information for us.
Thank you, Madam Chair. Senator Dornick. The plan is for this bill to go to State, Local Government, and Veterans Committee, the Judiciary Committee, and the Taxes Committee.
So it's fair to say that there's still a path ahead for this bill. It has a number of stops ahead, which in my mind also makes it important for us to get things started and moving here. And I will note for the record that I believe that there was a reference a couple of times to the legislative auditor's report, and I believe that that should be coming out on March 14th. So people can look for that and see what that report details and if it enlightens and informs us as to this legislation at all as well. Yes, Senator Dornick.
Thank you, Madam Chair. So is there a fiscal note to this?
I don't believe so. Do you have any comment?
Madam Chair, as I'm aware, no, but there's been a request placed.
Okay, thank you. Did you have anything additional?
Madam Chair, Senator Dornick, yes, a fiscal note has been requested but has not been completed yet.
Thank you.
Madam Chair, do we know how much time it takes to get one, an estimate?
Okay, do we have an estimated turnaround time for when we might expect to see the fiscal note?
Madam Chair, Senator Dornick, I've heard preliminarily, potentially early next week, but again, that's an estimate.
Very good, thank you.
Thank you. Just, will this come back after the fiscal note, since this is the committee that will be money, financing?
Madam Chair.
Yes, Senator.
I would just say that, like, yes, the primary jurisdiction is in labor, but, you know, we do have the commissioner here to answer specific questions. I think knowing that Commissioner Blissenbach, as well as the revenue commissioner, deed commissioner, like the agencies that have enforcement were part of this task force, they're aware of like the work that would need to happen for this partnership that will be created. We're not anticipating additional costs right now, but I would just, if you have specific questions, I would just ask the commissioners, you know, while we have them in committee.
Thank you, Senator. And we'll take a look at the fiscal note when it comes out and make a determination collaboratively about whether we need to take that under
Thank you, Madam
advisement.
Chair. I have an amendment, but we can wait if you want to.
Take other discussion first?
Yeah.
Okay. Senator Grunhagen.
Well, thank you, Madam Chair. Yeah, thanks for your comments, Commissioner. And I do have to say I identify with a lot of the comments that Senator Dornick made. You know, when I listen to the testimonies, both pro and con, I can tell there's a problem. I just wonder if this bill overcomplicates the problem for some of the businesses. And what I mean by that is, as I listen to the concerns in opposition, they seem to acknowledge that, yeah, there are concerns. They said, let's focus on the current laws, let's strengthen them and address what's the concern. But then they also brought up the negative ripple effect into their business, and they represent, you know, tens of thousands of workers also and contractors across the state, which I don't think you want to hurt with this bill, okay? So again, I just think this bill needs a lot more work. Number one, my understanding is, and that the OLA report has not come out. Is that correct?
Senator, I just had noted that it's, we anticipate it coming out on the 14th of March.
Okay, so to me, we're putting the cart before the horse a little bit when we don't even have the OLA report, which was designed to address this misclassification problem. And then on top of it, based on the testimonies of concerns, I think we need a lot more peace in the valley on this bill before it moves forward. Wouldn't you say, and I guess my question would be for the commissioner, wouldn't you say that you heard the testimony I did, and wouldn't you say this bill needs a lot more work to address some of the concerns that were brought up by those who were opposed or had concerns about this bill, Commissioner?
Commissioner, and then also Senator Oumou Verbeten, if you have a response to the question and the comments, please proceed.
Thank you, Madam Chair, and I'll make sure the commissioner can respond. Senator Grunhagen, I would just say in terms of the waiting until the OLA report, like I'm also eager to get the report and see what those recommendations are and what we can incorporate into this bill. But we did a lot of work in this task force. We heard pretty loud and clear from our agencies, labor, revenue, deed, commerce, like these different pieces of addressing misclassification that they have the authority and enforcement authority over, and they need to collaborate better. Like that's already clear. So that's why this is in the bill. It was very clear from what we heard from agencies in the task force.
Commissioner.
Chair and Senator Grunhagen, I would say that I am always open to feedback, and in fact, I have meetings set up to talk with about some of the concerns that were raised. But as I stated in my initial testimony, what we have done in this bill is a direct response to the challenges we have faced at the department in enforcing the laws that currently exist. Those challenges are real. They have, like I said, and I'll be completely honest and I'll own this, they have not set us up for success. We haven't been successful in addressing misclassification, and we need to have a more streamlined way to do that. And part of that is making sure that the incentive to not follow the law, because there are immense cost savings in misclassifying employees is not greater than the incentive to follow the law. And that is what we're trying to do here, is really set us up for success so that we can be addressing the problem before it gets even worse.
Thank you. Yes, follow-up, Senator Gruenhagen.
Oh, thank you, Madam Chair. Yeah, thanks for that response, Commissioner. I guess, you know, I've been around, was in the House for a number of years and now over here in the Senate. And it just, when I look at this bill and the testimony we have here, which again, we acknowledge there's a problem. And even those who opposed the bill or had concerns acknowledge there's a problem. But there's a lot of work that needs to be done on this bill. And as a member of the committee, to vote a bill like this out, just, you know, well, I hope it straightens it out on its way. I would be much more comfortable tabling this bill, getting some peace in the valley through the different stakeholders here, and then moving the bill on, rather than just moving the bill on with all these concerns that are out there. Again, you know, the people who opposed or had concerns didn't say there wasn't a problem that needs to be addressed. But they think this bill is going to cause more problems than it was going to solve. So I guess I would ask the author if we could table this, get some peace in the valley between the stakeholders before we move this bill out of committee. To the author of the bill.
Senator Oumou Verbeten, do you have any response you'd like to offer?
Thank you, Madam Chair. Senator Gruenhagen. I intend to keep moving this bill forward. We have done so much work on this task force, bringing together different stakeholders, and I am still more than welcome to meet with folks that we heard from today. I think we can get together with the Commissioner, we can get together with my, House author, and continue to hear those concerns. There's time for us to do that, but I really disagree with this idea that we weren't working with stakeholders, we weren't doing work on this issue before we even got to session. We spent a lot of time hearing from folks in the task force and coming up with these specific recommendations.
Thank you, Senator. Any follow-up? Yes, Senator Gruenhagen.
Yeah, just a final comment, not a question. You know, we had testimony that you didn't even meet with one of the stakeholders that had concerns about the bill. You didn't have an opportunity to. And I guess, you know, I have about 25 questions, which I'm not going to ask about the bill. But one of the concerns is it seems like, to a certain degree, and I could be wrong on this conclusion, we're weaponizing the Attorney General's office to just kowtow these businesses and increasing the factors randomly without having the stakeholder input from the businesses that are going to be affected. In effect, a general comment is we're getting rid of individual, of contractors, just willy-nilly. And if that's the intent, you could write a simple bill, no more contractors, state of Minnesota. And so I think the bill needs a tremendous amount of work. And I would strongly urge you to work with the stakeholders on all sides, because there is problems. I'm not saying there's not, but I don't think this bill is going to solve them. I think it's going to make more problems than it solves. Thank you, Madam Chair.
Thank you. Members, any other questions or comments, discussion for the bill? Yes, Senator Liskey.
Thank you, Madam Chair. Madam Chair, Senator Oumou Verbeten, thank you for bringing forward concerns. I actually have friends that have been, subject to some of this independent contractor situation. I believe she's a server at a restaurant, and for some reason she got labeled as an independent contractor, even though she had to show up for specific shifts, work at specific hours. That's not great. And my concern is, I have a couple questions, first of all, maybe for Commissioner Blissenbach first, and then we'll kind of go around with a couple more questions. But Commissioner, do you know how many complaints that were filed maybe in the year of 2023, just so I have an idea of how many we might have?
Commissioner?
Madam Chair, Senator, I don't have that number. I would encourage your friend to contact the department because that sounds very problematic. But I do not have the number. And to be honest, the complaints come in many different forms, like I mentioned. So your friend, for instance, may just call our wage and hour division and say, I wasn't paid overtime. That would be a wage and hour complaint versus somebody calling in and saying, I think I was misclassified, and maybe not indicating the wage and hour issues. So it might be challenging even within our internal system at DLI to know how many complaints specifically touch on misclassification. And then take that in addition to the complaints that come into deed after somebody may file for unemployment and find out that they have no wage credits because their employer didn't classify them as an employee and therefore didn't pay into the UI system. So they're denied unemployment on top of that. So we would need to look at deed, revenue, DLI, and potentially the Attorney General's office to really get a good understanding of how many complaints come in related to misclassification. And even then, it probably doesn't tell the full story.
Thank you, Commissioner. Follow-up, Senator Lewski?
Thank you, Madam Chair. Thank you for at least identifying where we could maybe fix some other errors in reporting and how we compile this information. So with that, I appreciate the answer. Going forward, Senator Oumou Verbeten, how many hours did the task force meet? I know it was just recently created. How many meetings have you guys had? Where are we at on that?
Senator or other testifiers who would be able to speak to Senator Liskey's question?
Sure, thanks for the question. We've been meeting since September. We've met monthly, except in January. We had 2 meetings in January so that we could both hear testimony and discuss the issue and then make recommendations for this bill. We've met between 2 and 3 hours each month. Yeah, those meetings are all also public and available on the Attorney General's website.
Thank you. Senator Liskey, follow-up?
Thank you, Madam Chair. Yes, so I'm also sitting on a task force, a different task force. It's revolving around ORAC. I'm sure some people know what it is. Other people don't know what it is, and that's okay. And it's a very busy group as well. So I can understand and I appreciate anybody that serves on them because they're not easy to serve on, for sure. So with that being said, the information that I could find from your guys' recommendations was pretty vague in comparison to how direct and descriptive this bill is. Is there a reason why we went from a vague to a very, very distinct definition?
Madam Chair.
Senator, yes.
Thank you. Senator Liskey, can you point out what vague description you're referring to?
Was my question as well. Yes, Senator Liskey.
Thank you, Madam Chair. Madam Chair, the only thing I could find was a couple of PowerPoint presentations that were talking about the reason during the last meetings that you guys had, and that was really all I could find for information on recommendations.
Thank you.
Was that from your packet? I'm sorry.
After you.
Was that from your packet or was that from online?
Yes, Senator.
Madam Chair, and to answer that question, it was from the task force recommendations online. So it was an online PowerPoint presentation that I.
Great. Under the February 7th.
Ma'am, could you just address me with
I'm sorry, Chair.
That's all right. I
I'm
just
so
want to
sorry.
make sure to keep the conversation.
Yeah, thank you, Chair.
Thank you.
Yeah. Under the February 7th task force meeting, there is a document called Adopt Policy Proposals that were adopted on February 7th, which is it's a bulleted list of the recommendations that were adopted by the task force.
Thank you.
Yeah, sorry.
Yes, and Senator Oumou Verbeten.
Thank you, Madam Chair, Senator Liskey. Yes. I was just looking through my many papers here, but the policy proposal that was adopted on February 7th, that should mirror pretty closely the description that I think was in your packets as well about creating the misclassification, enforcement, and education partnership, which is the bulk of this bill. It also does talk about some of the specific things for the Department of Labor to do to, modify some penalties and enforcement.
Very good. Thank you, Senator. Is there anything that you'd like to add, Commissioner?
Yes, Madam Chair, Senator, I should also add that I think the week or the task force meeting prior to when we adopted the recommendations, I did do a more in-depth PowerPoint presentation that specifically talked about Chapter 177.72, or 181.722, 181.723, and 326B, which are the primary places that this bill is addressing the Department of Labor and Industries Enforcement Authority and Penalty Authority.
Thank you. Follow-up, Senator Liskey.
Thank you, Madam Chair. Madam Chair, Commissioner Blissenbach, Senator Oumou Verbeten. I guess my concerns are that of what we've heard from some of the testifiers today. It's both coming at a very fast rate. I think that the August date is kind of a very quick turnaround for when these individuals might have to change a few policy purposes. Now, don't get me wrong, I think that misclassification is absolutely terrible. Like I said, I started with a person who I know very close that has experienced misclassification. So it's not that I don't disagree that this is an issue that we need to focus on. I'm just concerned at the speed at which we're maybe moving might be a little bit quick. Maybe there's an agreed upon, we can change it, slow it down a little bit, still address the issues. And the other problem that I see is that it's very heavily punitive. I don't think that there are mistakes, as we might say. There are intentional things that are done to try and skirt proper employment, proper things. And I do agree that there might be a need for change of those punitive damages, but maybe not to the extreme that this bill has. So that's, I guess, one of the concerns that I'm worried about. So, thank you.
Thank you, Senator Liskey. All right, members, any other discussion or questions, comments on the bill? Yes, Senator Dornick? I think you can go ahead.
Thank you, Madam Chair. So we had a task force. Well, I'll go back. So history is so important as far as this independent contracting. This has been going on for a long time. I remember when I first got in the trade, I faced this. I was an independent contractor at, 22. And so we've come a long ways. It was needed, and there's no question. It's still happening, but not to the extent. So I guess my question is, I think there was a task force in 2011. Is that correct? Does anybody know? If we get a little background from that task force, and I know that there was a bipartisan support of this. I think Senator Bach was really key in that, and I don't know if there's anybody that, and if you can't, that's okay. We can talk offline, but I just thought maybe there'd be a little of that history we could bring forward and just what was done then, and just a thought, but we can take it offline too if that's putting you on the spot.
Commissioner, do you have something to that effect that you want to add quick?
Yes, Madam Chair, Senator Dornick, I believe it was 2007, but I might be slightly wrong on that date, and that was in advance of some of the changes that were made that led to the construction misclassification statute 181.723, and what I think the department is bringing now is the fact that in our enforcement of that law, we've seen many, many challenges that have made what the intent was not possible, and therefore are trying to address those.
Senator Dornick.
Thank you, Mr. Commissioner and Madam Chair. So I guess I know the one concern is the 14-point test from the 9. I think that's concerning to some that I've talked to. And again, I think that it sounds like you're willing to work and talk, and I'd love to meet with you and go through some of the issues that are giving concern to the business owners. I know that they, like I said, there was 11 of them here that they wrote in the packet, and I'm sure you have it too. So that means a lot to me, and I do want to thank you for that and be able to navigate through some of these issues that are very concerning. And next week when the OLA gives the report, and some of the research that they're going to show to us. But with that, I do have the A2 amendment,
Okay.
Madam Chair.
Could we please have the A2 amendment distributed? Make sure we also get one to Senator Oumou Verbeten so she can take a look at it. Thank you. While this is being passed out, Senator Dornick, would you like to speak to the A2?
Thank you, Madam Chair. Yeah, this is pretty pretty short. It's just making the effective date, pushing it out there. So it sounds like this bill is going to move forward, is what I'm hearing. And we talked, I know one of the testifiers mentioned the effective date being, I don't know if it was July 1st or August 1st, whichever of this year, and having to implement all of that and try to figure out exactly how all the bill applies. I haven't had the time, and I know there's attorneys that are looking at this bill that are struggling with just trying to figure it out and the ramifications and some of the consequences, both, unintended consequences. So basically all it's doing is pushing it out there to July 1st of 2025.
Senator Oumou Verbeten, would you like to respond?
Thank you, Madam Chair, Senator Dornick. I'm going to ask members to vote no on this amendment as written, just because this would apply to the partnership itself, the effective date for that being created. And I think that's really crucial that that starts right away. That better coordination amongst agencies is, again, one of the most crucial parts of the bill. I'm definitely open to looking at a later effective date for some of the other components that we've heard some testimony about that folks are nervous about, want to make sure they understand what's expected of them. And then we can continue to have those conversations, and it's something I'm open to. But as this is written, no. I'd ask members to vote no.
Thank you, Senator. Senator, before we take a vote, any last comments on your amendment? Oh, I have a comment. Senator Liskey, go ahead.
Thank you, Madam Chair. Yes, it's to the A2. So Madam Chair, Senator Oumou Verbeten, if we were to modify this amendment to only, to allow the partnership part to go through, but the rest of it to put on hold until July 1st, would that be something you're amenable to?
Senator?
Thank you, Madam Chair. Senator Liskey. If you have a specific amendment that you can bring forward that outlines that, I'm definitely willing to look at it. I think the partnership is the piece that I'm most concerned about, but there are some pieces that the Commissioner and Department of Labor and Industry, I would like them to get started on earlier. This is also something that we can address in some future committee dates, the effective date. It might be good to talk with some of the folks that we've heard from today to figure out what pieces they're most concerned about, to then address with an effective date. But if you have that specific language, please share it.
Thank you, Senator. Senator Liskey.
Madam Chair. Madam Chair, thank you. I guess that was kind of what I was trying to figure out is, can we just get it done today so that we don't have to argue about it in a different committee and worry about it in another committee? Being that this is our committee of origin, this is our realm of what we should be dealing with. Is there any way that maybe you two can take a couple minutes, quickly pick out the sections that you're not wanting to this date to go forward, and then we just make that oral amendment very quickly?
Madam Chair.
Yes, Senator, go
I
ahead.
don't have the concerns,
Yep.
so I'm willing to have those conversations with folks, but I'm not the one bringing forward those concerns.
Understood. I think the answer is no, Senator Liskey. We're not going to entertain that today. Anyone else to the A2 amendment? All right. All in favor of adopting the A2 amendment, say aye.
Aye.
All opposed, say nay. Nay. The amendment is not adopted. Members, any further amendments or discussion on Senate File 4483 as amended? Yes, Senator Grunhagen.
Yeah, thank you, Madam Chair. Yeah, just one quick question. I mentioned I had about 20 of them, but I'll just use one. You know, when I looked at the bill, there's a stop order provision in there where the Attorney General can stop the work or have it stop work. I don't have the bill right in front of me right now. He's put it up in front of me.
I think we know what you're referring to.
Yeah. So does that order happen when the person's actually found guilty? Then you can do a stop order? Or if he's just suspected of doing something wrong, or
Or she.
breaking the law, that you can stop the order, stop the work just on a suspicion. I mean, he has to be, to me, he should have to be proved guilty before you stop the work versus just a suspicion where you stop the work on a construction. So I just like that clarified.
Thank you for the question, Senator. Senator Oumou Verbeten and/or Commissioner Blissenbach.
Thank you, Madam Chair. Senator Gruenhagen, I just want to clarify that piece falls under the Commissioner of Labor, and I can let her speak to more specifically to your questions.
Commissioner.
Madam Chair, Senator Gruenhagen, yes, that is a provision in 326B, which falls under the department's authority in the Construction Codes and Licensing Statute. And the way that works is a stop work order can be issued to the entity that has violated the applicable law, or who has failed to comply with a final notice, a final administrative order, or a final licensing order issued by the department. And yes, it does allow us to stop the work of that entity that has violated the provisions of the law. But there's also a process by which they can challenge the stop work order, or the department can lift the stop work order if the entity comes into compliance.
Any follow-up, Senator?
Yeah, just a quick clarification. So in other words, if a business owner or a contractor receives a stop order from Dolly, then, and he doesn't believe he's guilty, he can challenge that and keep working, or does he have to stop work immediately based upon a suspicion of Dolly?
Commissioner.
Madam Chair, Senator, the order would take effect. The entity would need to comply with the order. If they didn't, they would be subject to noncompliance with the order. But they can challenge the stop work order through the process that's outlined. But we would not issue a stop work order unless we have done the internal investigation to determine that there is a violation of law. This is not something we take lightly. It's authority that we have in, for instance, Minnesota OSHA has that authority. In my time, I can remember one instance where a red tag, that's what we call it in OSHA, a red tag has been issued and shut down a facility, and it was because there was a significant risk to the employees. And so it's not a situation that we take lightly, but it is a situation that works. The U.S. Department of Labor has what they call a hot goods provision, where they can stop the sending out of any goods produced in a facility after there have been determined that there are violations of applicable labor laws. So this is very similar to that, and it has proven to be effective.
Thank you, Commissioner. Any follow-up, Senator Gruenhagen?
Just the fact that I wish, I would suggest they need to be guilty before, this looks like they're guilty before, they're guilty before their chance to prove themselves innocent versus innocent before they can prove themselves guilty. So anyway, I wish that was clarified a little clearer so that you give these business people a chance to respond to the so-called infraction before they have to stop the work. That's my suggestion.
Yes, Senator Dornick, we're reaching our time here. If you could, we'll all try to be brief. And any final comments, Senator Dornick?
Yeah, thank you, Madam Chair. I just wanted to thank Senator Oumou Verbeten, hope I got that right, for the bill, and I look forward to working with you on this. And Commissioner, it's always a pleasure. Thanks for coming in. And I thought since there's so many construction guys out there, I would tell a little story. It'll be a 2-minute one about construction. And so just the speed of sometimes, we've got to be careful on how we do our work here, because the foundation is so important. So I was at 1991, the ice storm. I don't know if anybody's old enough to remember that. Terrible year to work outside. I was working outside with my brothers and sisters on a job in Rochester, and I was on the deck crew, and then you have the column crew. Well, the column crew pours their columns first, right, to get the height, right, and then the deck built to that. And so I don't know if you were on this, Leroy, or not, but I don't think you were. And, the job, I can't remember. There's a guy that back there that when I was an apprentice, he took me and just became a mentor and a friend, still a friend. And so the columns were poured, and the guy that was setting the height set them too high. So then the columns are about a foot higher than they should have been. So before we could set the deck, they had to jackhammer those, every one of those columns down. So you're going to see, our work is going to be seen as we do laws. So we want to make sure that we get it right the first time. And that's what we're talking about as, it's so important. And I look forward to working with you. And that's the end. Thank you, Madam Chair.
Senator Gruenhagen?
Roll call, please.
Senator Gruenhagen has requested a roll call. A roll call has been requested. It will be granted. Thank you. Senator Kubek.
Thank you, Madam Chair. And I want to just thank you for bringing this bill forward. Misclassification of workers is a huge problem, not only, I think, here in Minnesota, but across the United States. Do a quick Google News search on misclassification, and it is rampant, really, across the United States and in a lot of places. And I, too, my son was in high school a swim instructor and was labeled as an independent contractor. And as a dad who had to then do his taxes at the end of the year and do a 1099 and explain to this poor kid why a whole chunk of his money had now been taken away because he had to pay the side of the Social Security and the other taxes that would normally, if you were an employee, employer-employee share. And so remember always that misclassification is not just misclassification, it is in effect a form of wage theft, because those people are doing it. And true independent contractors, the beauty of, you are a true independent contractor, you have, when you do your taxes, you have an ability to write off a whole lot of things as an independent contractor. I had a business where I was basically, little sole proprietor guy, and you know what, I got all kinds of mileage I got to write off and things like that. But my son, as the swim instructor, he didn't have anything to write off on his 1099, and so he got stuck paying a lot of that. So I think this will be a good step going forward. I think next week, too, when we get that OLA report, this has a lot of committee stops ahead of it, I understand, and we can, if there's things we need to incorporate into that or any changes, I think we will have opportunities. So thank you, and thank you for everybody here who's shown up and taking a little time to support this, too.
Thank you, Senator Kubek. Any other members? All right. I also want to echo thanks. Thank you to everybody who testified today, and in particular, the workers who came to tell us the stories about the things that you've experienced and your desire to see your legislators address this problem, which has been around for many years and has been a major problem for Minnesotans and is right now, today in real time, a major problem for many people. I think we can get this right the first time. I think we will. And I trust very much in the work of the task force that was done over this last year, and collaboratively as this bill moves forward through the process. We have this process of going through these committees for a reason. As it makes all the stops, there will be opportunities for amendments if they're needed. But I'm very pleased to see this legislation come forward. And I just want to thank all of the stakeholders who have put the time and effort into putting something together where we can actually make the law effective for people, not just have it in paper, but have it work for people and enforced properly. So a roll call has been requested. If we could proceed with the roll call.
Madam Chair.
Oh, I'm sorry. I'm so sorry. I give the floor to our lead author of the bill, Senator Oumou Verbeten. Thank you for interrupting my process here.
No, thank you. I will be brief, Madam Chair. I just wanted to offer a few final comments as well. And first say, I clearly have many meetings ahead of me. I look forward to those with any members of our committee, folks who testified today. There's time for us to chat, and specific feedback, specific things you're concerned about. I definitely heard those today, but that's really helpful for me moving forward, and I look forward to having those conversations. I also just want to thank all of our agencies that do this work and are trying to do a better job. They really do try to educate folks first and foremost before getting to the place where we have to enforce. And when we were on that task force and we heard about some of these most egregious cases, it's just so heartbreaking. And the thing that I couldn't get over as a member of the task force was that workers who finally were brave enough to come forward, and they were trying to piece together all these things to get back wages, or to get back other pieces that they were denied, denied as because they were misclassified and things they should be entitled to as employees. It's just like the bureaucracy that they were put through is just horrible. So we really do need to streamline the process. When we talk about having this like one-stop shop, it's so important for that worker experience. It's important for our business owners too. It's important for our entire community. But that is the thing that really stood out to me as a member of the task force, was just like how heartbreaking it was to try to piece together navigating, our systems and our agencies. And I commend them for being a part of this task force and coming up with a solution to work more collaboratively with each other. And I really, again, just want to thank, again, those workers, our brothers, our sisters, and siblings in labor who showed up and are here today. You did the work to make this possible, and I look forward to continuing to move this bill through our committee stops.
Thank you very much, Senator. Senator Oumou Verbeten, would you like to move that Senate File 4483 as amended be recommended to pass and be re-referred to the State and Local Government and Veterans Committee? And then upon that motion, we will take a roll call as it's been requested.
Yes, thank you, Madam Chair. So moved.
On that motion, please conduct a roll call.
Chair McEwen.
Yes.
Vice Chair Hochschild. Yes. Senator Dornick.
No.
Senator Grunhagen.
No.
Senator Kupek.
Yes.
Senator Liskey.
No.
Senator Marty.
Yes.
Senator Oumou Verbeten.
Yes.
Senator Pappas.
Yes.
Senator Wiesenberg.
No.
There being 6 ayes and 4 noes, the motion passes, and Senate File 4483 as amended is recommended to pass and re-referred to the State and Local Government and Veterans Committee. Thank you very much, Senator, and thank you, attendees. With that, the Senate Labor Committee is adjourned.